120 words per minute. Ready? Start para. Mr. Patki learned EGP for the state would context the petition. He would place reliance on an affidavit in reply filed by one Rajesh Kalidas Lovekar, Deputy Registrar, Cooperative Housing Society, dated 13th January 2025. Mr. Patki would submit that there is a preliminary objection raised in this reply on the maintainability of the petition, mainly on the ground of an alternate statutory remedy available to the petition under the provision of MCS Act. The petition ought to have exhausted such remedy available under Section 91 of the said Act instead of directly approaching this court under Article 226 of the Constitution of India without prejudice, and in the alternative to the above submission, Mr. Patki would contend that the affidavit in reply filed by the state addresses the concerns raised by the petitioner. In this regard, he would submit that the state is fully conscious of the need to have appropriate infrastructure for electric vehicle, including installation of private electric vehicle charging ports within the premises of a housing society. In this regard, he would refer to the draft conditions for an individual EV owner to install a private EV charging ports within the society premises. The said draft conditions, paragraph. Mr. Patki would further submit that the additional registrar in bracket housing bracket close cooperative societies by a communication dated 14th July 2022 addressed to the divisional joint registrar cooperative societies has informed that note of such draft conditions as forwarded by the additional commissioner of MCGM in respect of setting up of installation of private electrical vehicle charging ports within the premises of cooperative society be taken. The said communication read, paragraph. It is submitted that pursuant to the above, after considering the availability of space for such installation, including the society and security aspects, necessary action oblique steps can be initiated for installation of electric vehicle charging ports. He would submit that in the light of the above, necessary steps oblique actions are being taken by the state and other concerned authorities in terms of the communication dated 14 July 2022 for issuance of no objection certificate to occupants for installation of private electrical vehicle charging port within the society premises. He would thus submit that the above measures sought to be taken by the state and concerned authorities would effectively address the grievance concerns raised by the petitioner. Paragraph. We have heard learned counsel for the parties and with their assistance peruse the record. Paragraph. At the very outset, to our mind, issues raised in the petition are significant not only from the perspective of advancing technology in the automobile sector but would equally touch upon the positive impact of such electrical vehicles in reducing vehicular pollution. This is quintessential to the recognized legal principle of substantial development as stated by the Supreme Court in Bombay Dyeing and Manufacturing Cooperative Limited versus Bombay Environmental Action Group. Paragraph. Considering the above observations of the Supreme Court, in our opinion, the requirements of charging stations for electric vehicles in societies today which would help reduce the menace of air, vehicular pollution, and the necessary legal framework in this regard cannot be overlooked. Paragraph. So also, after hearing Mr. Patki, learned AGP for the state and perusing the affidavit in reply of the respondent number 1 dated 13th January 2025, we do find that measures in the form of draft conditions for installing charging stations in societies for electric vehicle are undertaken. We may also observe that a communication dated 14 July 2022 placed on record by the state in its affidavit in reply would also indicate that the authorities are conscious of the modern daily needs to have such charging stations installed in societies for electric vehicles, the demand of which is on the rise. It is not as if that the authorities concerned are oblivious to the issues raised in the petition. We are conscious of our jurisdiction conferred under Article 226 of the Constitution of India 1950, which does not permit us to enter into the legislative domain of policy making. However, the aspect of having a clean, non polluted environment is an integral part of fundamental rights guaranteed under Article 21 of the Constitution of India, which too is vital and ought to wait on the mind of the authorities in taking prospective measures in the mass adoption of the technological advancements. Full stop.